And then outside Section 26 of the Electoral Act, Section 47 of the Electoral Act, Section 46 of the Electoral Act, all we say that you must pick a date certain to have an election, and that if election is not going to be possible in a particular area, ahead of that date, because of disaster, emergency, or whatever, you postpone the election. In the middle of an election or at the close of an election, they then say, hey, we want to postpone an election. They don't have the power to do. They did that in Imo State twice, 2011, and in the last election. They did that in Edo State, a one-off election. They did that in Ondo State. They did that in Anambra State in November 2013. One state, one office election, not even a general election. And now they are doing that now. And I'm wondering, why do you do so? You know, but now they've done so. And they are now saying that we are going to have a supplementary election, right? Now, if you have a supplementary election, as they are saying we should have, all they need to do is to say, between the time we declare that we are going to have a supplementary election and now something had happened, the candidate of the APC, Abubakar Audu, is dead. But because the election was almost concluded, and indeed he participated in the election, he voted, and so we have no power under the Electoral Act, under Section 68 specifically, to cancel the results. The only thing we can do in the circumstances is to continue with the election, because the APC is still on the ballot, the deputy governor is still on the ballot, and declare the result. When you declare the result, if they so declare the result that APC, their deputy governor, and their dead candidate won the election, if you are dissatisfied with that, you go to the election tribunal. That's the neatest, safest, logical, and the legal path to tread. Now, what they are doing is to say, yes, it's dead. What we're going to do now is that we're going to allow you to substitute. Section 33 of the Electoral Act allows substitution, but Section 36 provides a timeline. And it says that, yes, you can substitute, but that substitution must be between the delivery of nomination and commencement of poll. So you have to read the two sections together. You cannot substitute midstream. There is no law for that.
So that's the vacuum we're talking about.
There's no law for that.
You know, you pointed out two things here now. First,
so you cannot substitute.
A moment here, Mr. Ogunye. First, the issue of supplementary election is foreign to our Electoral Act.
They know.
Because it's not there, but we've always allowed it, and we've always allowed people to use that, because if you go to Section 70 of the Electoral Act, what it says, as you rightly put it, is even talking about fresh elections. If we have
if you have a
scenario,
stalemate, a tie,
yes, a tie,
equal number of votes, that's the only time you can have
a fresh election.
Or under Section 179, if on the first ballot there is no clear-cut winner, and then you go to the second ballot and the third ballot, as the case may be.
In law, you know, when you keep on with a mistake on and on, there must be a remedy. And since this has always been, when we talk about supplementary election, looking at the Constitution and the Electoral Act, and we just realize that it's not there, it is totally foreign to us. How can it be remedied since this particular election hasn't even held, now that they fixed
December 5? Is to abandon that illegality, no matter how long you persisted in error. Once it is pointed out to you, you backtrack. You hands off. You say, I won't do this no more. So that's the only way to do it. I'm saying that, look, the contemporaneous of election, the synchronization of voting is an irreducible quotient of the fairness of the electoral process. Because the outcome of the result in one part is not supposed to guide the other. That's why under Section 46, the time for the election must be the same. And they must feast that time before that election. But now they stagger it, they mess up election, and then now they've been doing this before without knowing that one day this kind of thing will happen, and now it's happened. That's why they're in this quagmire. And instead of them to get out of that quagmire, by some strange coincidence yesterday, the AG spoke. He shouldn't have spoken. About an hour or 2 hours later, INEC spoke. And about an hour or 2 hours later, APC spoke. All converging on what they want to do. I don't charge conspiracy unless I have proofs.
Okay, now
I talk about strange coincidence.
Then after they all spoke, the AG, the APC, and INEC, the PDP called. They said they contravened the provisions in the Electoral Act and the Constitution called for the resignation of the INEC chairman. And what do you think about this?
They are exercising the right to freedom of speech. You can call for the resignation of anybody, and it is given to the person to resign. So,
I wanted us to look at the AGF matter in this, knowing full well that there's always been a call.
Just to round it off, I'm saying I'm not calling for cancellation. INEC has no power to cancel. I'm not calling for substitution. INEC has no power to accept substitution at this stage, and the party does not have the power to substitute at this stage. I'm calling for continuation of the election. Conclude it. Go to the electoral tribunal. Just conclude it and go there.
So that it doesn't look more or less, partisan in nature. The argument of the office of the Attorney General and Minister of Justice has come again to the fore. His argument was talking expediency and politics more than law. Politics more than the law.
Than law. With due respect to him. Section 221 of the Constitution simply says that no political association, no association can canvass for votes other than a political party. That's what it says. That section has no bearing on what is going on. So what is the community reading that we are talking about? And I've just talked about Section 36. You can't read Section 33 in isolation. Okay? I know it's a difficult situation. You know, many lawyers have come here and have propounded several, resolution formulae. Initially, it happened, a lot of people were talking about cancellation until they were reminded that, no, and once you pronounce the result, you can't cancel. It is only the tribunal can do so. And then people then started grappling with the issue. So can they substitute until you now point out they can substitute? So what should they do in the circumstances? What they should do is what our prescribed they should do. That's what the law allows. And it's like a twin engine plane flying. Just before touchdown, one engine packs up. So what do you do to the plane? The plane must land. That's why you have a deputy governorship candidate. That's why you have the party. So I don't know what their problem is in their party, but I'm saying that I'm concerned about the rule of law and the Nigerian Constitution. I'm not so bothered about what is going on within the APC.
When you talk about having a deputy governorship candidate, what do you imply?
What I imply simply is that since INEC is insisting that it's going to conduct a supplementary election, since INEC cannot cancel the results, since no person can be brought in to inherit the results that had been garnered earlier, since Section 141 of the Electoral Act says that anybody who didn't participate in all the stages of the election cannot be declared the winner of the election, since all these are there, conduct the election, declare it as conducted, and let the parties, INEC will remove itself, federal government will remove itself, let the parties sort out the problem in the tribunal. If the tribunal then rules that, after the election, the first phase of the election, and the candidate died, the situation has changed. So that election could no longer be sustained. So we are now ruling that the election be held afresh. That would be the decision of a tribunal, a court of law, not an administrative directive under the rule of the term by INEC. That's what I'm saying. That's the path of the rule of law I know. Not for anybody to intervene and say that this is how it should be done.
So according to you, where does the deputy governorship candidate fit into the picture?
They had a joint ticket. They've garnered votes together. So he had that votes in his hand. He had accrued interest. His party had an accrued interest. You declare the result. When you declare the result, the provision of Section 181 of the Constitution will then follow. If parties are dissatisfied with that course of action, they go to the tribunal. That is the point I'm making. So you have two persons contesting an election. One died after voting, after the conclusion of poll, but before declaration of that person as the winner. So what should happen? So at that stage, you then start talking about substitution. And look at the problem they've encountered now. People are not thinking. Once you say you want to conduct a fresh primary, can you sustain the election you had before? Can you sustain it? once you say you want to have a fresh primary, as indeed they are saying, and that you are going to bring a candidate. So if that candidate comes, can you force that candidate who has the right to choose a deputy governorship candidate?
So in other words,
so
the deputy
they are
should
creating more
stand in.
problems than they intended to solve. I'm saying that rather than allow political consideration to sway you to the left or to the right, focus on the rule of law. Christians say that they need to perpetually discover the will of God and the purpose of God in their lives. What we need to do is to discover the will of the law in every given situation. And then look at it dispassionately and say, okay, this is what should be done.
In the light of this seeming confusion, so to speak, let's look at the role of the AGF and the Minister of Justice. There's been that call about separating the two of them so that one focuses on the law and the other stays on the politics of the law. How would that work out?
You know, we said this perpetually.
Would that have made any difference if we had that kind of separation?
That would have made a difference. But even when you carry the two legs of that office, you can be more circumspect and more cautious. I don't think that the Honorable Attorney General, Senior Advocate of Nigeria, ought to have spoken on the matter. There was a debate. A lot of people are saying, no, the Attorney General should speak. There should be an interpretation and all that and all that.
But is he in his place to give interpretation? Is it not the Supreme Court that should do it?
He ought not to have. Nobody was asking for his legal opinion on the matter. Although he has the right to exercise his right to freedom of speech. So I won't crucify anybody for speaking. I speak myself. So why should I gluten somebody for speaking? But because of the position of that office, and because that office is very important and it services the entire country, when a partisan matter like this, is a hotly contested matter like this is unfolding, the Attorney General ought to have been a little bit removed from dabbling into the matter. What happened yesterday, I couldn't miss the synchronization. Within a space of about 6 hours, Attorney General speak, INEC spoke, APC spoke, all saying the same thing.